Hi, y'all, and welcome to tonight's live stream. Aren't you really curious about what the Murdaugh jurors think about all the clerk of court Becky Hill drama? Alec Murdaugh, of course, we know was convicted of murdering his wife and son in the trial last spring in Colleton County, South Carolina. He now says he ought to get a new trial because of the fact that he says the clerk of court tried to influence the jury, tampered with the jury. So if so, he says he gets a new trial. He gets a do-over for his murder trial. Now, we have actual statements made by most of the jurors about what they think about the Becky Hill drama, and we are going to go over each of those. They're not very long. So we're going to go over each of those and then talk. What do you think? And I'll walk through them with you. So these were actually filed by the state as opposed to the Murdaugh team, which had filed 2 affidavits before, and then also 2 affidavits from jurors who, well, they were from a description by a paralegal of what the jurors had said, but they weren't actually signed by the jurors. So welcome everybody to Thanksgiving week here in the U.S. In the U.S., it's a week for being grateful, for thankful for all our blessings. We gather together with family, usually eat extraordinarily large amounts of food. At our church, we have Bluegrass Sunday, the Sunday before, which is a lot of fun, followed by a chili cook-off. So that's always a big thing for Thanksgiving. So today we are talking about the Murdaugh motion for new trial and the state's response. We're going to be looking at juror affidavits. They have the information that will make or break Murdaugh's request for a new trial. Now, he says that the clerk of court tried to influence them. We know that already on this motion for a new trial that Judge Newman will not be the judge for that. He has removed himself. We got that news from the Supreme Court, and we talked about that last week, that he will not be the judge. But whoever the judge is going to be making a determination on this motion for new trial about whether or not there was enough evidence of tampering or at least discussion between the clerk and the jurors that there ought to be a new trial for Murdaugh. Our structure for tonight is going to be, we're going to talk about what it is that we're going to look at so you'll know what I'm showing you, and then we're going to go over what each juror said. And we'll talk about the juror who's noticeably missing. So if you would, hit the like button and subscribe. We'd love to have you back for more. Let's start with what it is we're going to look at. Now, Murdaugh, as I said, filed the motion for new trial, but the state has now filed its response and attached statements to it. I'm going to show you that. These are the statements that the state attached to its response. So these are, written statements of jurors. So, and each juror has an individual statement. Now, the reason what I did was go ahead and type these up because you can see some of them are just really difficult to read. I'll show you some of them when we get like that. It's one thing if you look really closely and you can type it from the computer, but it's going to be impossible on the screen. So I went ahead and typed all of that out for you so you can just see it and we can talk about it a little bit better. So the comments in the middle, that's what I typed out. But I want you to notice a few things before we go to the typed out portion that I did. One of the things I want you to notice is the redacted part at the top. See all that black part? It's redacted at the top of every single one of these affidavits. This one is a little bit different. It's but see, over and over you see it redacted. That's the second page. You see it redacted at the top. So we know that, my guess is that was some kind of description of what they were supposed to talk about, something that kind of explained that to them. But that's just a guess. Since it's redacted, I can't know that for sure. That's my thinking. Now, they also, notice this, wrote voluntary statement, or in that case, supplemental voluntary statement at the top of these, which was good branding because they're saying this is something the juror wanted to do. This is a statement they're making, but it's all voluntary. And so that's sort of some branding by the state. This isn't an official form. Somebody made this up for the purpose of this, I would assume anyway, because, and some, well, who knows? Maybe they use this regularly for SLED. It was SLED, South Carolina Law Enforcement Division, that actually took these statements from the jurors. So maybe they use this on a regular basis. I suppose that's possible. But they redacted whatever it was that they said at the top. Maybe that was the juror's name and address, or maybe it was some questions. We can tell from these that there are some questions that they had to have been asking. That's really ironic. And let me show you why that's ironic. Let me get to my spot on the page just a second. All right, I'm going to head up here to page 3 and see if that's it. That's not quite it. Here we go. They're talking, one of the things that they talked about in their brief right above here, they talked about the fact that the person who ought to be asking the questions of the jurors is the judge. The party shouldn't be asking these questions. The judge should one-on-one ask the jury. If the prima facie showing is made, the resultant evidentiary hearing is a strictly limited, judicially conducted affair, particularly as concerns examination of the jurors. So it's kind of ironic that they sent someone out to ask all the jurors questions when they argue in their brief that the only way the jurors should be asked questions is by the judge. But we can tell that they did. And let me go over some of the reasons that we can tell that. Let me head back down to page 31. Okay, see how this person says, no, I was not coerced to give my verdict. No, I did not feel anything. They're obviously answering something. And for some of them, it's even a little more direct than that. Some of them actually wrote out the questions. If you can see in there, there's a Q. Did Ms. Hill ask questions about your opinion? A, no, she did not. So clearly a question and answer response. That was also true on page 39. If you can see it, this is the one that's so difficult to see, but Q&A. And then on page 40, little more clearly, you can see the question is written out and the juror's answer. So we know that they did ask some specific questions. So there are some other redactions too that were sometimes a little bit confusing. If you look up here, this one, it was really kind of funny because after the word no, there was something redacted and you're like, what? No way, no, something bad word that's not allowed on YouTube. You know, like what's redacted there? My thought was, after thinking about maybe initials, maybe they were taking out the initials because it would reveal who the person was. Maybe they initialed every single answer. That was the only thing I can think of. It seemed a little strange. This one had a redaction right in the middle, and you can see the signature redacted at the bottom. That one's kind of obvious, but there's a square right in the middle that got redacted. And then there was something similar to that on page 34, where you can see there are 4 little redacted sections. So there were various things that got redacted and cut out, and it's a little hard to know what they are. I wanted you to understand that just as we go in so we can have full disclosure of what we can see and what we can't see. Now, that actually creates some issues because, of course, the defense is going to say all of the questions SLED asked weren't good enough or were slanted in one direction. They were designed to get somebody to say exactly what SLED wanted them to say or what the state wanted them to say, and therefore they're not good questions. And so it's definitely going to be a fight, a battle as it comes through. Nonetheless, we got some good information. So let's take a look. Now, first I'll tell you 2 jurors who are not included, but were included on the Murdaugh side. Juror 630, represented by attorney Joe McCullough. So SLED, the state, could not talk to the witness. And this juror 630 said that Clerk Becky Hill said not to be fooled by the defense, to watch him, meaning Alec Murdaugh, closely, to look at his actions and to look at his movements. And then juror 785, also represented by Joe McCullough and known affectionately to us here on the channel as the egg juror. This juror was not actually a juror who sat on the case and made the decision about whether or not Alec Murdaugh was guilty. This juror was removed from the jury and sent home on the day of deliberation. So we've talked about that, got tons of videos on that, and you can read more about that. Now, I have marked some things that help the defense in green. I did that just to remind myself specifically of things to talk to you about it, so you will see that. So let's start at the top with what the juror said. Here is juror number 193. Making sure, yeah, that was pretty good. That's big enough. Oh, and I want to say thank you too to Armchair Apothecary. Thank you very much. I appreciate that. So the juror 193 said, no, I was not coerced to give my verdict. I came to the decision of my own free will. No, I did not feel anything was said to influence my decision making. I did not witness any private conversations pertaining to the trial and was not approached by anyone. I did not witness any juror speak privately about the trial. I did not feel pressured to come to a quick verdict or that I was required to reach a verdict in a certain time frame. I have not spoken to the defense team, and to my knowledge, no juror attempted to begin deliberations early. So we can see clearly they're answering some question that was posed to them, but we don't get to see what the question is because they start with no. Most of these questions or answers seem to assume that the only issue is whether or not the verdict was actually changed by Clerk Becky Hill's interference, as Murdaugh claims. Murdaugh's team says that's not important. We don't have to prove that the verdict was different. We just have to prove that Becky Hill went in there and tampered with or attempted to influence the jury. If we prove only that, that's sufficient. And the state says, no, you have to prove that everything was different, that the actual verdict was influenced or changed as a result. And that is going to be probably the most important legal battle of all in terms of this motion for new trial. Now, in this case, I personally side more on the Murdaugh side because the whole point of influence of a jury is that it's sometimes insidious. Think of, for example, of someone saying to you, you go to a movie and you come out before you've even had any chance to say anything about it. The person you were with is like, that was a great movie, wasn't it? And you were just about to say, it wasn't that great. So you say, yeah, it was pretty good. And it just sort of influences the way you talk about it. And so that is what the Murdaugh team is arguing here, that it doesn't have to be all the way. It's long. It's just a little bit of influence. That's what matters. So juror 254 says, this was my first time as a juror, and I found that this experience was very rewarding as a civic duty. During the time, we as a jury were treated with respect and received anything that we requested. The only time that I had interaction with anyone was through the bailiff. Other than one time when we as a jury was waiting to go into the courtroom and a comment was made to watch his body language. At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me of the decision that I ultimately made during deliberations. So notice several things about this one. First of all, this initial part is really not relevant to the question of whether or not the juror is whether of the questions that were raised by the Murdaugh team in the motion for new trial. That's sort of what happens when you just get people to write up statements as opposed to interrogating them, say, in a courtroom. There must have been questions that were out, but then the person seemed to just write down what they thought, and sometimes even in paragraph form, like this particular person. So that it's not really relevant that it was an experience rewarding as a civic duty, but it is kind of interesting because you can imagine where this could have been a very difficult experience. So it's great and a relief that this person found it to be something that was positive. But then we go to this sentence does help the defense. Other than one time when we as a jury was waiting to go into the courtroom and a comment was made to watch his body language. There is no person associated with that. Now, it was Becky Hill, according to Juror 630, who said watch his body language. That's what juror 630 said in the affidavit that was filed along with the motion for new trial. But this juror doesn't say who said it. It comes after the word bailiff, but there seemed to be a period then, and other than one time. So the assumption I make is that this person is saying that Becky Hill said, watch his body language. That is critically important for the Murdaugh team's motion for new trial, because what they are going to say is this is an exact example of Becky Hill trying to influence the jury by directing them on what to pay attention to and what to watch out for, focusing them on whether or not to believe him. And the Murdaugh team says that was unfair. The jury should just be confronted with the evidence and feel the way they feel, read it the way they read it. The person then ameliorates it, makes it a little less direct by saying at that time he didn't take it any way other than to watch his body language, and it didn't persuade the juror of the decision that the juror ultimately made. So that takes away some of it, but it still suggests that that comment was made. Okay, we'll keep reading. We will move next to juror 326. I believe that my interaction, I thought I had fixed this, with Miss Hill, the grout clerk, it was the court clerk, clear misspelling there, was limited to, by me, not by the juror, was limited to information from the judge or about important events such as graphic material or how long of a break we would get. I do not believe she acted outside of her role as court clerk and acted in a very professional manner. So this particular comment, as you can see, is not something that is direct. The part about the clerk acting in a professional manner, that's not really directly relevant. The question was whether or not the clerk made certain statements and whether or not the clerk interacted with the jury as related to the question of whether or not Alec Murdaugh was believable, credible, or giving valid testimony. And that part about the professionalism, while that's so subjective, I don't think that that is really exactly what the defense is aiming at. One thing that is extremely important and helpful to the defense here is the important events such as graphic material. This confirms, because this is one of the two jurors that we had that affidavit from the paralegal about. And the paralegal had said that the juror remembered the Becky Hill having said something about graphic material. Now that could be a problem. And let me back out for just a minute and I will tell you a little bit about why. Okay, so before a trial occurs where there are graphic photographs, for example, autopsy photographs, something after an accident where somebody is very hurt, in this case, scene photos of people who were shot, before those are shown to the jury, there is often an argument between the lawyers, and the lawyer for the defense usually will oppose showing the jury those photographs. The argument is these are prejudicial. They're going to sway the jury just because it's so bad. They're going to want to hold somebody responsible. And they may point the finger at the defendant, civil or criminal cases. They may point the finger at the defendant and say, look, this person has to be held liable because these are terrible photographs. So there's an argument that these are just prejudicial. They make the case seem way worse. Usually what happens is the judge goes through the photographs and then makes a decision. I'm going to admit this one and not this one, or all of them or none of them, but we'll make a decision based on the arguments by the attorneys. So this is a really significant fight that occurs before a lot of cases where there are graphic photographs. So if the comment drew attention, oh, these are going to be really bad photographs, that's the opposite of what the defense was trying to do by making the argument with the court. The court will say, I realize these are prejudicial, but I'm going to let these come in anyway because I think they are that important. In this particular case, if the clerk actually made statements like, ooh, these are really graphic, ooh, you better watch out, these are going to be hard to look at, that could definitely have an impact on the jury. That's actually, maybe it seems small, those little two words, it's actually pretty important. It plays directly into something that happens at trial, and a dispute between the prosecution and the defense that's very common at trial. This now, the going back to the question of what this juror says right here, the juror said more things than that, according to Holly Miller's affidavit, the paralegal who wrote the affidavit after interviewing this juror. According to Holly Miller, the juror also said that the bailiff and Becky Hill told them, "You will not get smoke breaks during deliberations," which the juror took to be something that suggested that they were being forced to deliberate fast, that they needed to get this done, that they were in a hurry. The bailiff, a group chat was formed with the jurors, according to what Holly Miller wrote in her affidavit, and he or she dropped off. This particular juror dropped off. There were just too many chats, didn't want to stay in it. That jurors, more than one, discussed the case before deliberations got started, and that jurors were, in fact, even telling coworkers about the case. So I wanted to pull out and tell you that. Now let's go on to juror 530. Just a second. Got a lot of windows open here. Let me switch over to, okay, here we go. 530. This juror said, "I did not at any point feel pressured to make a decision throughout the trial, nor did anyone attempt to sway my decision by," and oddly, this was redacted. I was like, why? "Any means of communication. At no point in time throughout the trial did anyone attempt to have a one-on-one conversation with me for any purpose regarding the trial. To the best of my knowledge, there was no court official or employee that questioned myself or other jurors regarding the trial or its outcome. To this date, I have not been contacted by the defense regarding the new allegations or other topics. Throughout the trial, I did not observe anything that I perceived to be unethical by any court employee." Now, this is another one that's very general and not always on point to what the defense is claiming, but it is solid, I think, for the prosecution. For example, at the comment, "At no point did someone attempt to have one-on-one communication with me for any purpose regarding the trial." Well, communications one-on-one was sort of minor, other than as to Becky Hill and the foreperson. And another comment in there, "To the best of my knowledge, there was no court official or employee that questioned myself or other jurors regarding the trial or its outcome." It wasn't really that they were questioned about it. It's that they were influenced. So I think that it's not exactly on point to what the defense is arguing, but I do think it's clearly very solid. And I want to thank Armchair Apothecary again. Thank you very much. Just 1 second. Let me reset over here. And we will keep going through our jurors as we head through. Wow, lots of great comments. Thank y'all. I'm excited. Okay, sorry. We are now up to juror 544. "While on the jury, Miss Hill never made me feel as though she was trying to sway me, either way, innocent or guilty. Miss Hill spoke to us as a group in regards to what type of things we would like for snacks, breakfast, and lunch, which is entirely appropriate. Miss Hill mentioned if we were sequestered that we would be staying at a hotel and we would be given time to gather our things to stay at the hotel. She also stated that an agent or officer would be with us the entire time. I felt she stated this to us as trying to keep us informed of what may or could happen. I was never made to feel pressured to say or do anything by anyone, court employees or co-jurors. I never witnessed any jurors going into a room alone with Miss Hill." The reason why I highlighted that part about Miss Hill mentioned if we were sequestered that we'd be staying at a hotel and be given time to gather our things was that some of what the Murdaugh team had complained about was the idea that the jurors were thrown into the verdict. They said that Becky Hill said, "This shouldn't take long. Let's get this done. This should not take very long." And I mean, I'm exaggerating, but that she said this shouldn't take long. And also that she then told them, "You don't get smoke breaks." We saw that earlier. "You don't get smoke breaks." And told them with no notice, and none of them had their bags packed or were ready to go, told them, look, you have got to, you will have to pack your bags. You'll have to go without a bag. You will be taken straight from here to a hotel, and you will not be given the chance to have your stuff with you. And I highlighted this in green just because it does mention that she said we would be sequestered and staying in a hotel. That is typically something the court would make a point of telling the jury in advance so that the jury would be ready. They would all show up on the, final days or the day of deliberation. They would show up and say, with their bag in tow, suitcase, so they would be prepared, because it would be very upsetting to think, you can't go home tonight. What if you have plans? Yeah, you don't even have your toothbrush. You are completely unprepared for that. And so that would be something significant. And that is one of the things that was being argued by the Murdaugh team. So let's keep reading about Juror 574. Juror 574 said, no, I was not coerced to give any answers. My decision was of my own. No court employee influenced my decision. I did not have a private conversation other than myself talking to Becky Hill about me not using the stairs because of my knee injury. Do I have y'all on the right page? I may not. There's so many different things. Okay, yes, I think I do. I did not witness any private conversations amongst the other jurors. I did not hear or witness anyone or any court official stating to us, the jurors, that we should not listen to the witnesses or it shouldn't take long, etc. No one made me feel that I had to arrive to a quick verdict, and if I didn't, I or the jurors would not be able to leave. No one from the defense team ever reached out to me pertaining to the Murdaugh trial. And they doxed the ed juror twice in here. At least they gave her name. It's not doxing, I guess, but they did give her name, but I redacted it. The juror that was ejected from the trial stated one morning on the van that her husband told her we were going to Moselle, and we told her no discussions. Now, I tried to spell everything the way the juror did. And if the juror had a phrase, I tried to put it in. If they put caps, I tried to put it in so you'll know. That's why sometimes Moselle is, I think, actually spelled with an S, but I spelled it that way because that's how the juror perceived it. So from this, you can see this person talks about, I was not coerced to give any answers, but coerced is a really long way from you were told to watch Murdaugh's body language, to keep that in mind, or to watch out that you weren't misled. And you were told that right before the defense presented the defense side of the case. So that was, I thought, it was pro-prosecution, but sometimes didn't hit exactly what the defense was trying to argue. Okay, number 589. I was a member of the jury. When we would go back to the jury room, people would go to the rooms where they wanted to. I couldn't quite read this. I think it said sit at. Most of them stayed in the same rooms from the beginning. Miss Hill would come in periodically to see if we needed anything and check on us. I did not feel rushed at any point to make my decision. And then question, did Miss Hill ask questions about your opinion? Answer, no, she did not. Question, did Miss Hill pressure you to speak to? And it looked to me redacted. I couldn't read it anyway. It was kind of blocked out. Answer, I felt no pressure to blank, redacted. I had my mind made up. Those redactions didn't really make any sense to me. I didn't fully understand them. I just put it in as I saw it. Excuse me. All right. Juror 729. During a 6-week trial, I found that with 2 different rooms, there would be a lot of gossip between strangers. Each room was filled with men and women. The room I was in was a quiet room, while the other room was louder and filled with conversations of work and private life. I spoke with Becky Hill on a couple occasions about my financial burden and that I needed to speak with the judge. Smoke breaks once a day, sometimes more. She did come speak to others, but I didn't hear the conversations. During the trial, I had a very uncomfortable feeling as a defense attorney would wave the gun around as if he had never held one before. During our smoke breaks, we would talk about lunch or what we were missing at work. There was always something to talk about or someone to talk to. After 6 weeks, it came time for deliberation. Everyone took an anonymous vote, followed by open discussions and questions. It was fast and smooth, but I felt no pressure. I was set in my decision. Just a second. After everyone discussed our thoughts, we voted again. Every vote came back guilty. We checked multiple times to see if all were comfortable with the decision. If we needed to wait, we would have. On the day of sentencing, we were approached by Dateline and Mrs. Hill, who asked if we wanted to do an interview. We told her no. She seemed disappointed, but let it go. I put that little section in green in because of the fact that the defense has said that Becky Hill really wanted the publicity that surrounded the trial because, according to the defense theory, she had a book. She wanted to get a contract for the book. She wanted to get a publisher. She wanted to sell copies of the book. And those things are the reason she pushed the jury and also pushed the jury to talk to the media. And she herself talked to the media and was interviewed on some of the various documentaries that were related to the case. Now, a few of the things in here, like, for example, waving the gun around, that's clearly not related to the motion for new trial. And some of them are smoke breaks once a day, seem to feel that those were not cut off at any point. So overall, some of it hits directly, but a good bit of it doesn't. The discussion about where the jurors were was certainly something that I was intrigued by. I wondered if some of these interviews may have taken place early on, just after the press conference and before there was a full understanding of where exactly the Murdaugh team was going to take its motion. So now 729 filled out two different forms. They may have gone out with this initial form and decided to redo it. But on the second one, there was a Q&A. Q, did you ever hear anyone tell the jury not to be misled or fooled by evidence presented in Mr. Murdaugh's defense? Answer, I did not hear anyone say not to be misled or fooled by the evidence. Question, did Ms. Hill ever ask you your opinion in regard to the trial? Answer, no. I did not have conversations with Ms. Hill like that during the trial. Question, did you ever feel pressured to make decisions prior to deliberation? Answer, at no point during the trial did I feel pressured to make my decision. So overall, there is a clear answer that they did not hear. This juror did not hear Becky Hill say not to be misled or fooled by the evidence. That's at least directly related to what the defense team is arguing. And it's pro-prosecution, obviously, because the defense team says that was said. It's possible this one juror didn't hear that comment. So if there are other jurors who did, it doesn't undermine that they heard it. It just doesn't support it. Now, the question about did Ms. Hill ever ask you your opinion in regard to the trial? That's not really the defense argument. It isn't that she went around and asked people what their opinion was. Although the ed juror did say she kind of fished for her opinion. And then the theory of the defense team is because Becky Hill thought that one juror was pro-defense, that was why she was so insistent on getting that juror off the trial. That's what the defense argument is. Now, the question about did you ever feel pressured to make decisions prior to deliberation, that isn't really part of what the defense alleged, but the juror answered it in a broader way, so I think that they covered including the defense argument there. So let's keep reading. We will go to juror 826. Did you feel pressured at any point during the trial to make a decision? No. Redacted. I put the line in there. Surely it's the person's initials. That's my theory anyway. Did any court official or court employee, and these may be the very questions that everybody was asked. This might be pretty close to it. It doesn't cover 100% of what other people seem to be answering, but it seems pretty close. So did any court official or court employee persuade you or any other juror one way or another as it pertains to guilt or innocence? No. Did any court official or court employee have a one-on-one conversation with you or any of the jurors? No. Did any court official or court employee have a one-on-one conversation with you or any of the jurors? No. Did I read that twice? I see. I put it in there twice. Did anyone attempt to contact you after the trial regarding the trial? No, except for the media. Now you might think, why is that relevant? What is that about? And I think what that is about is that there was a statement by the defense team that they had tried to contact the jurors and they weren't successful in getting them to, they were not successful in getting the jurors to talk to them. The jurors were refusing to talk to them. So they're trying to get in here. No, you didn't really try to talk to the jurors. So they're getting as many jurors as they can to say, no, that's not something correct. You didn't try to do that. I want to say thank you to Coco for the super sticker. Thank you very much. All right. Did you see anything during the trial that you perceived to be inappropriate or unethical? No, not that I recall. Did any court official or court employee question you or any juror prior to deliberation about decisions of the jurors regarding guilt or innocence of the defendant? No, not that I'm aware of. So those are the questions that may have been asked of all the jurors. And some of them are related directly to what the defense is talking about, and some of them aren't. For example, I think, did any court official have a one-on-one conversation with you or any of the jurors? That is directly on point to what the defense was saying. Did you see anything during the trial that you perceived to be inappropriate or unethical? That wouldn't answer the defense questions, but it's a very good question because it pulls everything in. It just makes it, make sure that you've covered everything. Did any court official, but this one, did any court official or court employee question you prior to deliberation? That wasn't really exactly what was being asked. So I would say that's a little bit off, which is exactly why the Murdaugh team is going to argue that, well, they did from the beginning. They said, don't send SLED out. Whatever you do, SLED shouldn't investigate. And now it'll have to be put into a judge, perhaps the attorneys for the two sides will be the ones asking the questions. And I want to say thank you very much for it. I made it too small. Don't worry, I'll put it back. I have to make it big enough. DB. Okay, I'm sorry. When it's up on my screen, it's too little. Thank you. That's really nice. Thank you. I'll blush if I read it, but it's a very kind message. And also happy Thanksgiving to you, DB. I hope that you have a great one and it's filled with blessings and joy for you too. And for all of our subscribers here. All right, let's keep reading. Juror 864. And this is our final juror. And then I'll tell you about the missing juror. All right, Juror 864. No one pressured me to make my decision of guilty. No one influenced me to make any decision or said anything to cause me to come to a guilty verdict. I did not have or witness anyone having a private conversation about the case. I was not told that I would not be able to leave until I made a decision. No one from the defense ever called or came by my house. I did hear blank. This is the, juror whose name I'm not going to reveal, but the state did say we are going to Moselle. So those are the jurors that the state showed us about. Let me remove that and then I can talk to you a little bit more about exactly about the missing juror, as I said. So in that particular juror, I thought it was a little bit off when they asked, did anyone attempt to contact you after the trial regarding the trial? But I think, this juror and others said no one from the defense called or came by. That was what the prosecution was really aiming for. So juror now missing is juror 741. Holly Miller had an affidavit from her. That juror said that Becky Hill had private meetings with the foreperson, told that a particular juror that no one from the media wanted to interview her, said, y'all are going to hear things that will throw you all off. Don't let this distract you nor mislead you. And that they talked before deliberations. So when you look at all of those juror affidavits. I'm really curious. What is your impression as I read through those? What did you think about those? They will get fleshed out. I said earlier that in some of my prior live streams, affidavits are not solid in the same way that testimony at a trial will be, because testimony at a trial, somebody can come and say, well, wait, I heard you say this. Is that what you said? And you can make it sort of fine tune it and figure out what the person meant. But when you write down, it just isn't quite as clear. And in this case, it's not as clear. It's just not. That's why these affidavits won't be sufficient. Somebody has to talk to the jurors in person. At least that's my personal opinion, is that somebody needs to do that. And that, according to the state, should be the judge. That's probably not going to be fair, given that SLED went out and already asked questions. So probably a fair thing to do would be let the defense ask some questions too. So I'm going to look real quickly for some questions in the chat to see if there's anything that y'all wanted cleared up or you wanted to talk about a little bit more. So remember to stick question marks at the beginning. I didn't give you a lot of notice. Sorry about that. But that is okay. I will look for question marks at the beginning. So put those in, and I got a couple more things I want to tell you about, and then I'll wait if you have any. Okay, so as we move forward toward the time when the judge is going to do something with the new trial, one of the biggest questions is whether or not there will be a hearing and whether or not it will be public. I can certainly see the judge saying that the hearing itself should be public, but the judge might decide that portions of it, for example, the interviews with the jurors, which is the most important part, would not be. The judge may decide that those aren't going to be made public. That the state has argued that they shouldn't be made public because those are statements that are being made by jurors who were called in. They did nothing other than just show up and do what they were supposed to do as jurors. They showed up and did their civic duty, and it's not fair to sort of harass them or to make it an unpleasant experience. They already spent 6 weeks at trial, a heavily covered media saturated trial. They were there and they've done enough. That's what the court is saying, or that's what the state is saying. But at the same time, that's true, as I've said in a prior live stream, anytime somebody is a witness, anytime they're a witness, they get called up and they get cross-examined and they didn't ask for it. Nobody said, I would like to do this. I would like to witness that car wreck. I would like to witness the murder. It just happened. And as a result, the way our justice system works, they do get asked. They do get cross-examined. They get put up on the stand, and then the other side gets to cross-examine them. So I personally think that should trump here, but I understand the court may choose something different. Jersey Jen is asking me, here is a classic example. Thank you, Jersey Jen. So Jersey Jen is saying this, in your opinion, this is not enough for a new trial. So that's good. I'm trying to be neutral and not give away my thought, because I want you to be able to think of this for yourself. What do you conclude? I would say, I'm trying not to say. For one thing, well, so I would say that misconceptions are often reached because I'm trying to be really neutral. I do think the more than one juror saying that Becky Hill made some of those statements is huge. That's really huge, really unusual. Never heard that before. And we had that on a couple of different statements that she supposedly made. The comments on the photographs that they were going to be graphic or hard to watch, that differed a little bit by juror. That is extremely important. And there are now multiple jurors who have said those two things. I think the judge will have to look at that very, very carefully. Here, how was that? Was that neutral, but maybe a little clearer? Okay, let's see. Jean Philpott is asking me, when will this be decided? There is no telling. There may not be a public argument that we get to see, and there may not be a hearing that's either public or announced, or even a hearing. This is a motion for a new trial, but it doesn't necessarily have to be decided with a hearing. I think there will be a hearing. I feel real sure there will be a hearing, but I don't know how much of it we'll get to see. I would think the court ought to make the decision that at a minimum, the public ought to be able to see Becky Hill testify. She's a court official, a public official, elected. And so I think that would be reasonable. We're going to go over her affidavit. There was an affidavit she filed, and we're going to cover that on another live stream and compare that to what some of the jurors said about what she said. We'll look at the two. Did she cover all of the points and all the facts? Because she says not surprisingly, right? She says she did not tamper with the jury. Okay, so Fallstar asked me, if the jurors say that those statements were compelled by SLED, what happens? So I understand what you're saying. I don't think the jury would go that far. I think instead it would be that SLED asked particular questions and pushed them to say, which sort of influenced, if you will. That's exactly the issue. Influenced them in a certain direction. But it would be more that it would just come out on cross-examination, and less that there would be a juror coming in and saying, I was forced or compelled to say that. Maxine is asking, will the paralegal be called in who reported the shorter cigarette breaks? I don't think so. I would think that that was all hearsay, and I don't think that will come in. I think instead the juror will be brought forward, and then the juror might be asked questions. Isn't it true that you told somebody blah, blah, blah? And they might deny it. But I don't think that the paralegal will end up being a witness. Just a guess. We'll see. And Summer is also asking me about the hearing, and I don't think there's a set deadline for when that's going to be decided. I don't even know if there's a judge yet. What we know is that there's not Judge Newman's not going to hear it, but I don't think we know what judge will be appointed yet. We will find out, hopefully. Two jurors who Leslie asking me about the two jurors who are speaking out didn't deliberate. Whether or not the two jurors who are speaking out deliberated. We know that juror 785 did not deliberate. And we know that because she was dismissed the morning of the deliberations. But there were actually 4 jurors who either gave statements or who were quoted by the paralegal Holly Miller. So I don't know on the other 3 whether they were seated jurors or whether they were alternates who ended up not actually being present and giving their final vote with the jury. So I don't know of the other 3 that they named. All right, let's see. Morpheus is asking, did you think that anything from about whether it was enough to get a retrial? Snowfire, will they get a different judge? Yes, they will. They definitely will. Dog Teeth, as some of these jurors came out in the distant future and said they weren't honest and were in fact influenced, would the whole thing be dragged back to court? No, probably not. They'll be put under oath. And if they go in and talk to the judge, even if the only person who asks them a question is the judge, I think they'll be put under oath first. And so if they try to undermine it later and say, oh, I lied, not only would that be a pretty risky thing to do because they would be admitting that they had lied under oath, but I think too that the court would say no, just as the court said that with Alec Murdaugh, when Alec Murdaugh said, I would like to change my testimony. I know that I told the insurance company that my housekeeper woke up just long enough to tell me that she had tripped over my dogs and fallen down my stairs. I lied. Though when I said that, I lied, and I did that just so I could commit insurance fraud and get a settlement. And the judge said, no, you can't do this. All right. Bushlight says, which juror was the 4-person, the one that was allegedly having conversations with Becky Hill? I wondered that too. I don't know. If anybody knows, please let me know. I would really like to do that. Okay. I'm going to, we've got Lisa. Oh, thanks. Lisa saying she enjoys the explanation of things. All right. Well, I am losing my voice. So great to see y'all. I go live Monday, Wednesday, and Friday at 7 p.m. So we will be back on Wednesday at 7 p.m. I want to thank Marlon, Mama Pinks for their moderating. I appreciate them coming night after night. And thank you so much to all of you who have subscribed to the channel and hit the like button. You mean a great deal. Thank you.